Hello, everyone, and welcome to Sandra's Stenography and Shorthand Dictations. Welcome, 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 everyone. Thank you so much for being here, and I appreciate your support. And I hope that these videos are really helping you. So, tonight, let's go ahead and get to it. We are working on selection number 58 still, but there is several parts to this recovery attempt by Heir. In case you haven't seen the videos that I've been uploading lately, they have all been, except the Jeffrey McDonald, on this recovery attempt by an Heir, and this is part 2. So this is pretty long here. So please, if you can catch up by going to, this is jury charge. So if you haven't been able to catch up, just go on the channel and click on jury charge, the jury charge tab playlist, and all of these will come up. So since we already did part 1 of this, from I believe 80 words per minute to 180 words per minute, those videos have already been done, and 200 is mixed in with that 180. So we'll go say 200 words per minute. And so with the new part 2, we'll be getting there again at 80 words per minute. And we'll take our time. Oh, wait, I haven't marked this off. Okay, so I haven't marked this off. So instead of doing that, because I have to mark it off so I can read it, I'll go back to part 1 and do the entire dictation. How about that? And you can use this for endurance. And the reason I say the entire dictation is because I never did the entire dictation at any particular speed. No, I did not. Because of the length of this is 1,279 words. So what I did was made you short videos of this. I think each one was at least 5 minutes long. So I'll give you this entirety tonight then. A little change of plans, but we still got some dictation. We'll always have some dictation to practice to people. All right. So we're doing section, so you don't get confused. We haven't not started part 2. We won't start that until the next video. This is still part 1. Selection number 58, 1,279 words, jury charge, subject, recovery attempt by Heir. In its entirety. And I think I'll read this at 100 words per minute in its entirety. Let me make sure give me 1 second. Let me get, since I'm changing speeds, I want to make sure. My chart up. Okay, guys. Ready? Handy dandy stopwatch right here. I believe it's going to take me about 8 minutes to read this at 100 words per minute, somewhere around there. Great for endurance. For you guys who are struggling with sticking with me longer than 5 minutes. Let me get my camera. That's a little bit better. Okay, guys, are you ready to write? In 5 or 4, 3. This phone better not go off. In 5, 4. Wait a minute, guys. Because I bet this phone is going to go off. Okay, good. It has been muted. In 5, 4, 3, 2, 1. That's right. Members of the jury, it now becomes the duty of the court to charge you in the law that applies to this case. This is an action on behalf of Miriam M. Johnson, as the plaintiff against the American Life and Accident Insurance Company of Toledo, Ohio. The plaintiff, for her cause of action against the defendant, sets out the corporate capacity of the defendant company, that its principal place of business is in Toledo, Ohio. For her first cause of action, the plaintiff says that she is the widow of Henry O. Johnson, who died in October 1955, and the owner of a parcel of real estate situated in the city of Columbus, Ohio. She further states that the estate of Henry O. Johnson was subsequently administered in the probate court of Lucas County, and that she, the plaintiff, was the sole heir. As such, she is now the owner of this particularly described piece of real estate. She further says that sometime prior to the 7th day of January, 1953, at the request of Raymond Swanson, agent of the defendant company, her husband, the decedent, entered into an agreement with the defendant and other individuals, whereby he loaned to the defendant certain promissory note, executed and delivered to the defendant, payable to the order of the defendant, in the sum of $5,000 within 5 years after date. Said note was secured by a mortgage upon this real estate described, which mortgage was conditioned upon the payment of principal and interest of the note. Plaintiff says that this loan was made with the understanding that said note and mortgage was to be deposited with the superintendent of insurance of the state of Ohio, in order that the defendant might comply with certain requirements demanded by the law of Ohio upon and of corporations of this character. Plaintiff further says that in consideration of the giving of this note and mortgage, defendant agreed that the note and mortgage would be returned to the plaintiff and canceled of record within 5 years of the date of the said note and or before its maturity. Plaintiff says that it was the understanding of the parties, and as part of the consideration for said loan, that said note and mortgage was never to be enforced against plaintiff's husband or against the property, and the sole purpose of its execution was to permit the defendant to begin business in the state of Ohio as a duly licensed company. Plaintiff further says that no consideration whatsoever, other than the promise of other individuals to loan similar notes, was furnished by the defendant for said note and mortgage. Plaintiff further says that the defendant has failed to cause to be released said note and mortgage, although demand has been made of the defendant. Alleges that the superintendent of insurance will not cancel and surrender the note until the sum of $5,000 with interest has been paid. That there is therefore due from the plaintiff the sum of $5,000 with interest, which the plaintiff claims from the defendant. Now, the defendant has filed a pleading in this case in the way of an answer, in which it admits that the American Life and Accident Insurance Company is a corporation doing business in the state of Ohio, that its principal place of business is at Toledo, Ohio. Further admits that the plaintiff was the widow of Henry O. Johnson, deceased, that she is the owner of the real estate described in the petition, and that the estate of Henry O. Johnson was administered in probate court of Lucas County, and that the plaintiff, Marion N. M. Johnson, is the sole heir of said Henry O. Johnson, deceased. Defendant further admits that on the 4th day of January 1953, the Henry O. Johnson referred to, executed, signed, and delivered to the defendant company a note in the sum of $5,000, payable within 5 years after date, admits that said note was secured by a mortgage on the property of the deceased, as set out in the petition. That said note and mortgage were filed and recorded. It further admits that said note and mortgage were made in conjunction with similar notes and mortgages of other individuals, with the understanding that said note and mortgage, together with the notes and mortgages of other individuals, were to be deposited with the Superintendent of Insurance of the state of Ohio, in order that the defendant might comply with certain requirements of law. These admissions just referred to, members of the jury, the court will say here, now dispense with further evidence as to those allegations made in the petition of the plaintiff, and for that reason, no evidence has been introduced in this case. It may be considered to that extent sufficient evidence. Now then, the defendant, pleading further, denies that it was the understanding of the parties and the consideration given for the said note and mortgage that it would be returned to plaintiff and canceled, and satisfaction entered upon the record as soon as this defendant company obtained funds or within 5 years of the date of the execution of the note. The defendant further denies that it was the understanding of the parties that, as consideration for the giving of said note, it was agreed by the defendant or anybody else that the said note and mortgage was never to be enforced against the plaintiff's decedent, and that the sole purpose of its execution was to permit the defendant to begin business in the state of Ohio as a duly licensed insurance company. The defendant further pleading says that this note and mortgage was given by the plaintiff's husband in return for stock in the defendant company in the sum of $5,000, that the records of the defendant company at this time show that this stock is now held and is in the possession of plaintiff. Defendant says that the plaintiff has sold a portion of her stock and that the balance she now holds, that this stock in the sum of $5,000 was issued to plaintiff's husband, and that the stock was the consideration for the giving of the note and mortgage as described in plaintiff's petition. The plaintiff denies that it now has or at any time has had sufficient funds to deposit with the Superintendent of Insurance, will not release, cancel, or return the note and mortgage as set out in plaintiff's petition, denies that there is anything due to the plaintiff in any sum whatsoever. The second cause of action pleaded in plaintiff's petition and referred to by the second defense and defendant's answer are not for your consideration, members of the jury, and you will have nothing to do with it. And that's it, folks. That's the full reading of Selection 38. For those of you who are interested in hearing that, you can also hear that on my podcast, Let's Write Steno. Be sure to go over there and check that out. I'll also download this so that you can hear it over there as well. I'll make a episode of it so you can hear it over there as well for those of you who prefer audio. And that's my poll question. Do you prefer audio or do you prefer video dictations? Let me know in the poll on my channel. I really, really, really would like to know. And thank you so much for joining me as always. And I think that's going to be about it. It's been such a pleasure. It's always such a pleasure to be here with you guys. I love what I do. I really do. I mean, I really, really do. So anyway, guys, thank you so much for supporting. Hit the PayPal button. Donate $5 today. Help me continue to bring you more dictations. Donate $1. I don't care. Every little bit helps. And after, let's see what's coming up soon. Later this week, Jeffrey McDonald, number 16. So look forward to that as well. Thanks, guys. As always, love, peace, and STENO.